Good morning. Did that recording work? Yes, it did. Good morning, good morning, good morning. It is July 18th, and we are so privileged to have David Young presenting to us. But before we do, the normal caveats that I always put in. First off, tell your friends to join. The more, the merrier. We love having you as part of our various groups. Please do come in, and we are going to have quite a few video sessions coming up. So, you'll get advance notice of that. And of course, you can suggest new videos that you want to be a part of as well. Second caveat, the same one as always. Our forums are private, but these videos are public. Anything you say can be recorded and will be placed on a variety of fora. So please be advised as to that fact. I actually have the distinct pleasure right now of introducing David. Part of the fun in doing this is that you meet so many of the people that you actually only correspond with by email all the time. And David and I have corresponded many, many times, primarily on assignments. I'll speak to David's acumen and diligence in representing his clients. I know this firsthand in negotiating for assignments and in ultimately constructing and understanding the nuances of the law, such that he is one of those people who, when his name is on the other end of the file, I know there will be no issue. I know it will be handled professionally. And above all else, I know that it will be handled with knowledge. David is one of those people who is working for an esteemed firm. All of us know Sorbara, but also really has a firm understanding of the intricacies of his work, deals with builders all the time, and has valiantly, I'm going to say, decided that he will step forward where others would not in describing what happens when a builder goes bust. We are in a different economic climate. And that economic climate is one where builders that have traditionally been indebted up to their eyeballs have always been able to refinance their way out of situations due to rising land values, but that's no longer the case. Moreover, new construction consumer bases have fallen off a cliff. And as a result, they're holding on to properties that they never anticipated holding on to, and their pro formas are askew. To that end, many of them simply can't hold on any longer, and like consumers themselves are experiencing pain. This isn't true of the Tridells and the Manamis yet, but it is true of the smaller builders. And the question therefore arises, what happens when you are the purchaser of a unit? What happens if you've entered into an assignment agreement? David has valiantly decided that he is going to step forward and tell us about that. It is my distinct pleasure to tell you that David, as a colleague, knows his stuff and is agreeing to present. And so without further ado, because you're not here to hear the melodious sound of my voice, but rather David's, I'm going to turn the attention over to him. David, if you'd please share your screen. And I would ask simply that questions be held till the end. I know David would be happy to entertain them, and we'll go from there. Thank you, David, for being here today. I turn it over to you.
Fantastic. Well, Mark, that was a fantastic introduction. I'm very happy to be here, and yeah, that was I'm blown away by that introduction. That's fantastic. So, a bit about myself, as Mark's already mentioned, David Young with Sorbara Law. There's my contact information on the first slide. You should see the next slide come up now. So this is our learning objectives for today, some topics of discussion. We're obviously going to talk about why is this happening to builders, how does the process work with receivership. We're going to concentrate on the court appointment rather than private appointment process. We're going to talk about some projects that are happening right now and the status of those projects. Then we're going to roll it back to how can you protect your client from when you first purchase these things, when you first sign the agreement, purchase and sale. We'll talk about your cooling off period, your deposit protection as well. Now, I do have a portion at the end for questions. If you have any questions in regards to specific slides that I'm talking on, I would ask that you wait until I finish that specific slide, and I'm of course happy to talk about your questions. Okay, so why are builders ending up in a receivership? So as Mark mentioned, what we're seeing right now is purchasers having issues. We've been seeing that for the last number of months. We're all aware of that. Purchaser defaults. I've had two this week alone. Classic appraisals come in too low. The mortgage rates are too high, and people have to go to B lenders or private lenders to try and bridge that gap. And unfortunately, these days that gap is just not being bridged. So as I said, we're seeing these purchasers defaulting, but on the opposite side, now builders are feeling that too. And why are builders feeling that? And what you'll see is a couple of points here, generic points, is that COVID delays. We know this well. That the due to the lockdowns and social distancing, etc. COVID-19 caused a lot of impacts. Each project is planned well well in advance, years in advance. And because of these shutdowns or slowdowns, this has really impacted delays. All the while, debts are building. The biggest thing related to COVID-19, as you'll see on the second point here, is materials and tradespersons. So we all personally experience skyrocketing prices for materials, DIY, we're doing at home during lockdown, and of course in the grocery stores, etc. But imagine this on a scale of hundreds of units at a time across multiple projects. That budget that is very well planned in advance is completely blown to pieces. So again, on top of these delays, you're increasing costs over time, over these unplanned years, can lead to a great shortfall of funds. And then the other big one is construction loans and mortgages. Rising interest rates, which we're all aware of on the personal side, also impacts these developers with the loans that they have, which again, on top of these delays and materials, will worsen the situation. It just puts an already delayed project further into debt. So that's the big reasons what we're seeing right now as why builders are ending up in receivership is really down to COVID. That's the beginning of the process. Okay. Now, next slide is how does the process work? Now, as I mentioned, the reasons why we're getting there, eventually when we get there, the builder will default on their mortgage or the loan, and the bank wants to take over and secure the property. They want to prevent the builder from doing something to reduce its value. They don't want the property to be left, let's say it's mid-construction, they don't want it to be left not wind and watertight over a winter period, for example. The bank wants to protect their interest. So what will happen is that there's two methods of appointing a receiver, the private appointment and the court appointment. We're going to concentrate mainly on the court appointment right now. That is the most common appointment because the court appointment is better for all interested parties. When it's private relies on what was in the original loan agreement, what was in an original loan instrument. Let's say something's missing in that private original agreement. If you go under the private appointment and there's no original powers, you can't get granted, you just can't go ahead with the process. The court process is much, much more strict. It's much more streamlined and it's just a much better process. And that's what we're seeing right now is mainly court appointments. Now, what you'll see is once, I'm going to talk about in another couple of slides later about the actual court process itself, but in general, a receivership process, either on the private side or on the court side, can lead to either an immediate sale or to a resumption of construction with a view to complete the project. Unlike some other methods that lenders might have, for example, a company's creditors arrangement, CCAA, where the debtor, the builder, maintains control of the process. Under a receivership process, it is the bank who retains control of the process, which allows for all interested parties to be protected rather than simply the builder itself. So that's again why we're seeing court appointed rather than private appointment. Talking about timelines and notice. So there's quite a lot of different pieces of legislation that covers receivership. I'm not going to go into each individual one because it is quite a complex topic, as you can imagine, and always changing at the moment. But as you'll see from a notice period under the Bankruptcy and Insolvency Act, they must notify the builder at least 10 days in advance that this receivership process is happening. Now, again, going back to one of my previous comments about depending on the project, the time of year, what's happening with the project, is it going to go bad weather, etc. There may be some exemptions made to that 10-day period if there's an absolute urgency to preserve or protect the assets. The short notice periods are important because, again, if the receiver is delayed, appointing the receiver is delayed, the property may be in danger. or end up in a worse situation than it is. As I said, I keep going back to this winter example, but think of a project that's frozen in winter. You really need to protect that to avoid any future problems. The last point here, creditors, how they serve is a demand letter and a notice of intention to enforce security, and they give that minimum 10 days to correct the default. But that receivership really is, there's been a lot of negotiations back and forth. There's been an attempt to refinance before. So I wouldn't say, as a builder, you wouldn't be too surprised that this receivership process is happening. So it's likely very rare for a builder to be able to get out of the receivership process on this short 10-day period. Okay. Next steps after the appointment. So as I mentioned, an immediate sale, it might involve simply selling all the assets and winding it down. That's what a standard receivership might be for a non-real estate property. But on a real estate property, especially if it's half constructed, there is an incentive to finish this project. So you may, as a receiver, find that they find a new source of funds in order to get the trades back on site. If you have, annoyed these tradespersons, you owe them thousands of dollars, tens of thousands of dollars, millions of dollars even, you're not going to get them back on to construct unless you have a new source of funds to pay them off and receive construction, which is the advantage of a receivership over a CCAA, where under a CCAA, they may not have plans for new funding. With the receivership process, you can pay these tradespeople and get them back on site to finish the project. Now, I'm going to talk about this on a slide later in regards to reviewing the pre-construction purchase agreements and your client's rights or no lack of rights, etc. But at that point, once the receiver is in place, they now have a chance to review these pre-construction purchase agreements and determine what they're going to do going forward. Okay. Next is specifically talking about court appointment process, since this is the most common method we're seeing right now for appointing a receiver compared to private. So there is a standard model type of order, which is used as a template. This has generally become the standard form precedent going forward. They'll use that order to appoint the receiver going forward to manage the property, the assets, the undertakings. This order will outline the powers and the duty of the receiver, and it will, of course, be tailored as appropriate. It does depend. Generally, what you see is these lawyers will submit a standard form and then blackline it out or make changes so that it can be tailored to the specific project. What happens is once the court order is submitted and received, it will be endorsed. And then next stage after that is that tender or bidding. So if they have decided to sell the property to a third party, then there will be an opportunity for potential bidders or other builders to make formal offers to complete the transaction. There will be a deadline set, of course, and again, under the model order, there will be requirements set by the receiver to ensure compliance, to ensure a fair bidding process. And again, under the court appointment process, all these bids will be approved by the court. The court process, like just generically to make generic comments, it's well governed. They're unlike the private, where you're relying on the original loan instrument. With the court appointment process, there's multiple pieces of legislation: the BIA, the Bankruptcy and Insolvency Act, the PPSA, the Justice Act. There's a whole number of legislation there. And also, once they're court appointed, the receivers are officers of the court, so they do have to act honestly and in good faith. Some of these cases that I'll show you later, we are seeing that there has been a bit of dishonesty amongst the builders. So having that court appointed receiver does bring some, it steadies the ship, because as I mentioned, they have to act honestly and in good faith. Another advantage of the court appointment process is that all proceedings against the builder will be put on a stay, which basically, in very simple terms, allows everyone to cooperate, brings all the creditors under the same proceedings. Let me have a look at the next slide. Another comment, as I was going to say, is the court looks at a range of factors. They don't just look when it's a private, they don't just look amongst themselves, or when it's under a CCA, they don't just look on behalf of the builder. The court will consider all the parties involved, consider what harm is being done by parties against purchasers, creditors, etc. After the tendering and bidding, notices will be provided to the purchasers. Throughout this process, the receiver is obligated to provide notice to these purchasers regarding what's happening. Now, a lot of these, well, back in the day, you used to receive letters, etc. Now everything is posted online. So, as I said, I will go through some examples later of some receivers. Let's say it's under KSV or EY, they will have a specific page. So once the purchasers receive the first notice, they can go online and look at all of the court documents and all of the records. It's going to be a lot of documents, hundreds and hundreds of pages to review, but there should be a summary provided every once in a while from the receiver to purchasers to inform them what's happening about their specific project. This is quite a difficult time for purchasers, and I will talk about later their rights or lack of rights. Okay. When I have clients, I do have clients in some of these projects I'm going to talk about later that are in receivership, and the biggest thing they ask me is time. How long is this going to take? Now, there's quite a lot of examples out there right now. Very generically, the court appointment process will take about 3 months for those authorizations to come through. Then the receiver will review the purchase agreements and determine if the project is still worth continuing and if they're going to sell or continue it themselves. So it's quite difficult to determine how long a sale might take. I do have an example later where I can show you how the last number of months, how it's processed recently. But that's the big question, is how long is this going to take? And the simple answer is it's difficult. It's very, very difficult to determine and give your client some sort of satisfaction. Now, talking about existing agreements of purchase and sale, as I mentioned, under the court-appointed proceedings, it's entirely conducted under the court supervision. Now, while this is in play, purchasers can't really do anything. They just have to wait. It's a difficult conversation, as I've had in the last couple of weeks, couple of months. Clients are not satisfied. The other thing is generally the court-appointed receivership order will state that purchasers cannot bring an action to terminate their own purchase agreement during this time either. As I mentioned, the other creditors, there's a stay in proceedings. This also applies to purchasers in limited circumstances as well. They cannot pursue during this time while the receiver is figuring everything out. Okay. Looking at the bullet points I've got here, as I mentioned, the receiver is going to appraise the property and look at market values, look at what it was originally sold at. It was sold for X amount. Now looking in 2024, it's worth Y amount. They're going to determine if it's worth it to continue with these purchase agreements or if they can be terminated and resold at a higher price. Now, if it is terminated and resold at a higher price, then original purchasers are entitled to the return of their deposits, pending deposit protection, which I'll talk about later. But the original purchasers will then generally be offered a right of first refusal to come back into the project, either with the similar unit or different floor plan, depending on how they've decided to relaunch the project. But most definitely, it will be a higher price compared to what they bought it at a number of years ago. On the other hand, as you see here, the receivers also have the option to simply cancel all of the agreements in purchase and sale altogether. One of the examples I've got later, you'll see they've sort of done a hybrid where they've decided to keep one part of the project going and the other part of the project cancelled completely. Okay, so again, unfortunately, while all of this is in play, you do have to have difficult conversations with your client, with your purchasers on what's happening. And as I mentioned on these receivers' websites, there's a lot of information. Your client's going to be asking you to go through all this information and trying to decipher what's happening. Okay. Now, looking at the sort of economic viability, for these projects going forward. As I mentioned, the receiver is going to look at the original purchase agreements and compare the price at what it was sold at compared to the fair market value today. What we see is projects are cancelled when the simple math is that we're not going to get enough money in the door. There's no profit involved in this project now because of the increase in supplies, as I mentioned, the delays and the original price and the fair market value today. Sidebar, that's why we're seeing a lot of purchasers default on their purchase agreements for closings now because they bought during the height of 2021 or 2022. And now the valuations are simply not there. The banks are not supporting the valuations. The appraisals are coming in lower. And from a purchaser point of view, there's no economic viability to continue. But from a builder point of view, they will also look at that going forward to see if it's worth going ahead. For projects, what I'm seeing is that for projects that are almost complete, it does make financial sense to continue and finish the project. Either the receiver will finish the project themselves or they'll sell it to another developer who's interested in completing it. Obviously, if it is almost complete, but some of the units are unsold, it is more viable to sell a finished unit than it is for selling a unfinished unit, a hole in the ground. So you also have to look at the lender's point of view as well. It depends on their attitude and if they're willing to work with the receiver going forward. If the lender can see that it's almost completed and there's going to be a quick turnaround, is the receiver or another builder going to get in quickly? Are they going to finish this project and get out? Is the lender going to get their money back in a short period of time? Is it going to be 12 months, 24 months, 36 months? That really is, it depends on the attitude of this lender being able to reborrow again. So what you'll find is that the earlier the project is in the process, the less likely that it'll be continued. There's just simply potentially no economic viability to continue a hole in the ground. And then if you look at something, so we discussed the beginning of the process and the end of the build process, something that's in the middle of the process, again, to keep going back on my winter point here, is that if you have a project that has been mismanaged prior to receivership, there's going to be long-term problems. I've read of a project out in Waterloo that was left for over winter, and it was left for so long that it's going to cause major problems, and that's going to lead to costs later to fix the problem and disappointed purchasers as well. You expect, when the whole reason why you buy a pre-construction property is to get a brand new product, like buying a brand new car, you want to get 3, 5, 6, 7 years out of it without any problems. So if you have a brand new product that is now closed and you're having issues to do with mold, etc., that's a big problem. So that turns off lenders from that type of project, mismanaged and left to rot in the meantime. Now, talking about timeline to sell, now that we're just from a common sense point of view, now that we're seeing more and more projects fall into receivership, when there was the odd receivership and there was a lot of money floating around in the market, what you would find is a project may be gobbled up relatively quickly by a competitor, by another builder. But of course, now as more and more projects go into receivership, more and more builders go into bankruptcy, the pool of potential builder purchasers gets smaller and smaller. And then, of course, the interest rates where they are, it might not make it attractive to buy this project. So if you said to me, well, is it going to take 6 months? It might take 6 months today, but with more and more projects going into receivership, we may find that timeline is increasing and receivers are unable to sell a project. Okay. Now, to talk about some examples here, Van Dyke is one of the biggest ones, and the one that's a bit of a mess at the moment with so many different projects that are falling into receivership. This started last year. You'll see in the slide here that it started back in November of last year, and it has been slowly moving through the court-appointed process. KSV is the receiver for most of these different projects under the Van Dyke Group. So there's 8 different projects or sites at the moment that have been declared insolvent, which is over 2,000 unbilled units, 2,000 units. So that's a lot of unhappy purchasers at the moment. KSV is looking to recover over $350 million over these projects. And each project is sort of moving individually. So some projects have been listed for sale. So others have been terminated. You'll see here that the Backyard Kingsmill has been sold, but they have decided, the new builder has decided to terminate all of those purchase agreements, and they're going to relaunch the project. Lakeview, so that's 2 different towers. They've now put them together in the one receivership process. DXE East and West were relatively close to completion. So the receiver, KSV, has decided to finish it themselves, or get a general contractor to finish it for themselves and complete it. So that's a positive development for any purchasers that are in Lakeview. For Backyard Kingsmill, this is very recent. It was only sold at the end of June, and purchasers were informed of that, I believe, June 28th or so. The good news with the Backyard Kingsmill is that deposits are fully insured because this is a condo project, and they're going to get all their money back. For a freehold project, it is a bit different, and I am going to talk about later about deposit protection and the differences between a condo and a freehold. There's another one for Van Dyke. You may be aware it's the Ravine. That's a freehold. So the deposits are not insured over a limit, again, which I'll talk about later. So Van Dyke, very complicated right now. Lots of very upset or angry purchasers. Again, going back to my general point, is that purchasers really have a waiting game while they wait and see what's going to happen with each of these individual projects. But this is a good example of a timeline right now. So the Backyard Kingsmill, that was probably 6 to 8 months for the entirety of the process between appointing a receiver all the way through to sale. But again, as I mentioned, with the volume of receiverships going up and the number of builders out there willing to buy, that timeline may extend out. Okay. Next is we have the one. So this is the big one right now. Everyone knows about it at Young and Bloor. This is where it sort of kicked off in the media that Mirazi has his development company has fallen into difficulties, and a receiver has been appointed. I know there was some sort of drama between control and attitudes, mismanagement, etc., which I can't really comment, but it's a very large project. You'll see that it's $1.6 billion of debts here. It's going to cost $2 billion based on current estimates to finish this thing, which is, of course, way up from the original budget, one of the last budgets in 2019 of $1.4 billion. And it's up for sale right now by the receiver for a minimum bid of 1.2. So based on my most recent reading of the proceedings on the one, is they haven't found a buyer yet. But what they've done is they've not terminated any purchase agreements yet. But amongst the top floors, the very large units, you're talking, $10, $20 million condo units, they haven't sold. So they're looking at potentially simplifying the floor plan and making it more smaller units, cheaper units, to try and get these sales through with a view to maximize how much money they're going to bring into this project. So very, very expensive project, very in the radar at the moment because where it is and the name attached to it, and the drama going on between everyone internally. But of course, now that it's court appointed, everything is going through a strict timeline. As I mentioned, they have to follow the standard form, standard timeline. So that hopefully gives some comfort to potential purchasers within the one. So that is Van Dyke in one. Next, there is one that just went 260 High Park. This was Track Developments. EY has been appointed the receiver very recently. There is $42 million in debt owed to Meridian and other lenders on this one. The interesting one with the Track Developments is that the directors, the 2 original directors for the developer, continue to make statements, which I've not really seen before. They seem to be arguing their case publicly and sending notices to purchasers and posting items online, etc. So it's be interesting to see where this one is going to go. 260 High Park is about 60% complete right now. So it's a bit difficult to determine if what's going to happen if the receiver is going to continue it themselves or find another builder purchaser, or if the developers themselves are going to try and fight this out. I'm not sure what's going to happen. So this is going to be an interesting one. I do have a couple of clients here in this development as well. Next is the Grace in Richmond Hill, Jefferson Properties. So I mentioned this one earlier about it being a bit of a hybrid situation right now. So this contains condo, townhouse or townhome units, and also freehold townhouse units. It's about 60 to 70% complete right now, 40 million in debt, very similar to High Park. But what they've done is they've recently announced that any freehold townhome unit is being cancelled. It's quite interesting reading. They sort of tear into the developer for building something very luxurious with a rather poor design, with high construction costs to complete, and as promised, level of quality and inclusions. Which means that there's no profitability. They're making a loss on the freehold units. So they've decided, the receivers decided to terminate only the freehold units and continue with the condo units. Now, I will talk about deposit protection later on, as I mentioned, but any freehold purchasers here, they've all paid, the majority of them paid over $100,000 in deposits, which is the limit for freehold, as I'll show to you later. So they are in a bit of a sticky situation right now where the amount is not protected. But as I mentioned, I will go over individual deposit protections later in my slides. Okay. Another one that was over the media recently is a project in Ottawa where it became a bit mismanaged, it seems, because they were unable to lease out the retail space, the commercial space, which has caused some cash flow issues for these projects, these 3 different projects out in Ottawa by Ashcroft Homes. Again, this one right now has a small amount of debt, but nothing has been decided on these purchase agreements, or it hasn't been sold yet. So that is quite a lot of examples to show you. I'm going to move on to the deposit protection next. Some big names there at the moment going through, especially Van Dyke. But again, it's all public record, so I'm not really talking about something that you can't go discover yourself. Okay. So talking about deposit protection. So as you're probably, everyone here is aware of what the Tarion Warranty Corporation is. They are the body that administers the warranty for Ontario new build properties, and there are specific deposit protections listed under that act and administered by Tarion. So for freehold homes, you'll see that there is a protection of, for a purchase price up to 600,000, your deposit is protected up to 60,000, which probably doesn't impact a lot of developments now because most things are over 600,000. Excuse me. So you'll see here, if it is over 600,000, your deposit is protected for 10% up to a maximum of $100,000. So this is where we're seeing that if your deposit exceeds the $100,000 limit for these expensive properties, you have no protection. You're simply a creditor. The government has not made, I couldn't, maybe perhaps there's rumors floating around, but there's nothing concrete posted on any online or any press release of whether they're considering increasing this limit. From our point of view as interested parties, yes, they need to increase this limit, or as I'll talk about later, you need to negotiate this at the beginning to offer additional protections. The standard wording.
I hope you don't mind me just stepping in for 1 second. David, I'm not sure if you're aware, but the Homeowner Protection Act that was just passed fully increases the limits and all protections, but it's not yet being passed. They're doing consultations. It's expected to come into force next year.
Next year. Okay.
Yeah, but the legislation's already passed to enable it.
Okay, perfect. Well, as we know, government's off on its vacation for now, for the summer break, but that is fantastic to hear that they are going to get it into next year. So these slides will be irrelevant as of next year. But I will talk about later the negotiation you can do for now in the event that we have a change in the legislation or an election and a government change. Okay, so condos is much clearer. A few different levels of deposit protection on condos. We have the first $20,000 is covered by Tarion. Any deposits for condos are required to be held in trust under the Condominium Act. And if money has to be withdrawn from the trust account in any way, there's a very strict process that these builders have to follow. They have to get excess insurance, ECDI, excess condo deposit insurance, if in an excess of $20,000 is to be pulled from the lawyer's trust account. There's going to be a cost consultant looking at what's going on and looking at the specs of the property, where it is construction-wise, viability, etc. So the cost consultant and the insurer will approve the funds before they can be released from the lawyer's trust account. And of course, if your purchase agreement is terminated, your deposits are entirely protected, and it will be must be returned to you within 10 days. Okay, so very clear for condos. It's generally always been this way for condos since the Condominium Act came into play. Mark, thank you for your comments on the freehold. That is great to hear. Now, I do a lot of assignments. Assignments are potentially the most complex type of standard residential type of purchase that you can do these days. As Mark mentioned, it's good to have the correct team involved for assignments because there's so many different factors involved, costs involved, etc. Now, what happens on we're going to say what happens on an assignment if the builder goes bankrupt. So for those of you who are not aware of what an assignment is, you have an original purchaser or an assignor, they're called eventually. They purchase an agreement from the builder. They agree to buy property 1, 2, 3, 4. It's going to close in 2026, 2028, whenever it is. Let's say they have a change of circumstances where projects delayed, life circumstances have changed, they have kids now, etc., or they simply want out of the purchase. You can flip or sell that contract to a third party, which is called an assignment transaction, if you have the consent of the builder, which we can talk about separately. I could talk about for a while on the various limitations on that consent, but that's the simple concept: is you flip the contract to someone else and they step into your shoes and you generally walk away without a care in the world. But what you have to think about is what happens if there is an assignment and the builder falls into receivership. So I'm sure you're aware of Greg Whedon from our Facebook group. I certainly refer files to him, and I'm sure that you refer files to him as well. He is a fantastic resource in Ontario at the moment. We have a case fresh out the printer that he argued recently for our signees, where this exactly happened. Is the builder went bankrupt and now they terminated the project. The receiver decided to terminate the project. And we were arguing, Greg was arguing that in simple terms, if the builder project is cancelled, therefore the assignment agreement itself is cancelled and all parties have to return back to the original standings. Now, my point of view is that this was pretty clear cut. There's a paragraph in the standard ARIA Form 150, article or paragraph 17, which basically says that if the seller or the builder voids the purchase agreement, then the assignment agreement is void itself. What happened in this case, specifically looking at some notes here, is that this clause states that the assignor, the assignor is not liable for damages incurred by the assignee. So let's say the assignee goes to buy another property and they pay more. They're not liable for that. But what they are liable for is they have to return the money. So just let's say, for example, say that the original deposit with the builder was $100,000 and the profit paid on the deal was $100,000. What happened in this case was that the assignee was able to get their $100,000 deposit back from Tarion because they assumed the purchase agreement. Tarion provided coverage, of course, and they were able to get their $100,000 deposit back. The question here was the profit. Where is the profit? The assignor was refusing to pay the profit back. In this example, $100,000 of profit. Greg was successful in arguing this Article 17 with the judge here, Justice Cameron, to say that, yes, if the builder transaction itself ceased to exist, then the assignment agreement needs to go back to where it was originally, and all parties need to go back to where they were originally. So this goes to show that our reading, myself and Mark's, was correct. Greg is fantastic in arguing this case and creating a precedent. But it does go to show, be very careful when entering into an assignment. Again, I could talk about assignments till I'm blue in the face, but again, as you may be aware, there's different ways to structure the profit or the return or payment of the profit. A lot of back in the day when everything was going gangbusters, a lot of assignors would say, pay all of our profit up front. We want it now, before final closing or before interim occupancy, before either closing dates. Or you would negotiate that, let's say, some of the money is paid now, the rest of the money is paid later. There's different ways of doing an assignment deal, but it goes to show that this example shows is you need to be very careful with the type of project you're buying into and your associated payment structure. If you're buying, let's say, a hole in the ground, you should never pay your profit up front to a property that's not near completion, because more and more now, as we're seeing, projects that are holes in the ground are never going to be finished. And let's say your assignee client, your purchaser client, has paid $100,000 in profit to the assignor, you're now going to have to go and chase them for this money. You can rely on Greg's case now as precedent, but you're still going to have to go through the whole process of suing them to get your money back. So very, very important. I personally would never recommend paying any profit up front, but it depends, of course, on the negotiations that you make as agents, and that I suggest as the lawyer reviewing the purchase agreement or the assignment agreement. But it just goes to show that you will get your money back if the builder goes bankrupt, but you're going to have to fight for it. So very, very important to have your assignment agreement reviewed by a lawyer like myself or Mark during the conditional period to get recommendations on whether you should pay your profit up front or not, depending on the state of the project. Okay, so very, very important case for us going forward, and on assignments, pretty complicated. Okay, now let's say we roll it back to when you're originally purchasing this new build project. As you're aware, there is a rescission or cooling off period. We want to talk about delay dates on how long they can push these things, and we're going to talk about deposit protection as well. So cooling off periods. Purchasers of condominiums have always had a 10-day rescission or cooling off period since the Condominium Act came into play. Those 10 days start once the agreement purchase and sale has been fully signed, and for condos, the disclosure agreement has been received. It's based on calendar days, not business days. What I find is I get a purchase agreement on a Friday before a long weekend. That does eat into the time that we have to review the purchase agreement. The whole reason why you come to a lawyer is for us to give a review, give a breakdown of your estimated closing costs, development charges, utility connection fees, and then we can negotiate lawyer to lawyer for caps or reductions of costs, especially in this market, sidebar, especially in this market with a slow sales environment, is that we used to sort of ask for a couple of things, but now we go for the shotgun approach. Let's ask for everything we can and see what sticks in this environment. But again, the 10-day cooling off period has always been there for condos, and it provided a great protection for your clients. Now, up until last month, there was no mandatory 10-day cooling off period for freehold homes. What the government did is, under that Homeowner Protection Act that they rushed through just before they closed for the summer, is they added a 10-day cooling off period for freehold homes. For me, as the lawyer here, this was great. To go back to the example of a Friday of a long weekend, let's say that the freehold builder wanted your clients to come into the office on a Saturday morning to sign the documents. I would get a blank copy of the purchase agreement on a Friday afternoon at 3 p.m. How the hell did I have time to find to review that? So for me, this is great consumer protection now. It allows us to properly review the purchase agreement, properly give us a chance to negotiate caps, etc. Because you as an agent or you or your purchasers individually walking into a sales office, they might not know what to ask for. They don't know what to negotiate for, etc. And you would, get a copy of the purchase agreement the following Monday or Tuesday and find that the development charges are uncapped, and it's a firm deal. So this for me is a very, very important change, adding a cooling off period to freehold homes. Okay. Going forward, as you may be aware, builders have a construction period. This is an example for a condominium on when they can sort of bookend the interim occupancy dates. So what you'll find in your purchase agreement, there's a statement of critical dates at the back. They're mandated to provide you this. There'll be a first tentative occupancy date or first tentative closing date for freehold. This will be the earliest date that they think the unit's going to be ready. They then have to give you a notice period to tell you if there's going to be a delay on that first tentative occupancy date. They can delay you then to the outside occupancy date. So this is sort of the bookend between the first and the outside. The builder during that time, as I said, can delay you between the first and the outside. Once you do get to the outside occupancy date or outside closing date, your client then has 30 days during the purchaser's termination period to decide to terminate. Now, this on my next slide, I'll show you an example on one of the bullet points here. So there's a project in Toronto that was launched last year. Will remain nameless for now, but they have the longest bookend, the longest between first and outside date that I've ever seen. They say that they're going to be ready for occupancy between 2029 and 2045, which is crazy. Do you want your client calling you every year for the next 20 plus years asking what's happening with these projects? I certainly don't. So during this period of time now where we have a lot of power to negotiate on these purchase agreements, it's highly recommended that we try to negotiate these dates down, because otherwise your client's stuck in this forever, right? Well, not forever, but they're stuck in it for a very, very long time, a very, very long period, where they are earning a small amount of interest on your money, depending on where the Bank of Canada rate goes, but the money's stuck there. They're stuck in this purchase agreement. Circumstances would definitely change over 20 years. They're going to be married, had kids, grandkids, dead, etc. Lots of different circumstances. So that's why it's very, very important, again, to get a lawyer in during your cooling off period to review this purchase agreement and perhaps try to negotiate these outside occupancy dates down. Okay. Delayed closing compensation. This is another sort of sidebar before we go into deposit protection. Delayed closing compensation, it's available in limited circumstances where if the builder has set a firm closing date and they have to delay through their, let's say, own incompetence, then your clients are entitled to claim $150 per day up to a limit of $7,500 under your Tarion delayed closing compensation. Unavoidable delays, which, as I mentioned right at the beginning, as such, COVID or trade union strikes, etc., they aren't entitled in most circumstances to closing compensation. So that has sort of blown a lot of these projects during COVID. You're not entitled to the compensation, but if it's through their own competence, they make a mistake on notifying you of delays, or they simply mismanage the project and they can't get the occupancy permit, there is a compensation available for your clients. Okay. Next thing to negotiate at the beginning of the process, deposit protection. As I mentioned, right now at this time for freeholds, there is a limit. The best way to protect that is to negotiate to have those funds held in a lawyer's trust account, or to mandate deposit insurance if the funds are to be released. As Mark mentioned, the legislation is in process and hopefully this will change for next year. But if you are entering into
I must interrupt again, David.
Yeah.
I wrote this in the chat. I know you're busy doing this. I made a mistake in that, and I'm so sorry. It was part of the draft we were trying to get in. It didn't make it into the final legislation. I'm truly sorry, and I'm very I screwed that part up. So please excuse me. And I was going to say it during the questions, but as you're bringing it up again, I'm just going to interrupt. I was wrong. I apologize.
Okay, no problem at all. I mean, that's why we're here, is to bounce thoughts, ideas off each other. but definitely something we want to see. Hopefully, we have a change of mind in the government going forward, and we can have another stab at getting this change. So this slide is now extremely important going forward. Then, no matter when you're buying, is to negotiate. See if the builder is willing to negotiate. Now, let's say the builder's lawyer comes back and says, "I'm going to charge $250 per deposit check to hold in trust." That is well worth the money. Again, looking at from your point of view with a relationship with a client, do you really want in a couple of years' time for a client to come along and say, well, you could have told me to put the money in trust, I would have paid the money, right? Now I'm short. Now I've paid $150,000 and the projects went under and I'm only getting $100,000 back from Tarion. So very, very, very important for this to be negotiated going forward. Okay. Now, I do have an open floor now. I don't know if Mark has all the microphones turned off or if you can just unmute yourself if you have any questions.
I do. The best thing to do is if you have a question, I know a lot of information was covered here. Can someone just raise your hand and then David can call on them? It's probably the easiest and I'll help facilitate as well. So if anyone has a question, please feel free to raise your hand and then we'll just call on you and you can go ahead and ask it. Usually takes people like 10 seconds before they decide they want to be the first person to ask.
Yeah. It is a complicated process that we are all getting more and more familiar with going forward. But we have one question here.
Yeah, we have Sanchita. Go for it, Sanchita.
Thanks, Mark. Thanks, David. Really good presentation and lots of information. I guess I just wanted to know, because I also do a lot of these pre-construction agreement reviews. So if it does happen, and personally, my parents bought one of the Van Dyke properties, which is obviously with the receiver now.
Yeah.
So I guess I wonder, do we just wait and see what happens? And it is a condo, so I know they'll have the protection built in. But do we just wait and see what happens and hope for the best? Like if the receiver ends up selling it, what are the chances that the purchasers do end up getting beyond what Tarion protects them for? I guess just, to know, like, as to how do we deal with these scenarios?
Yeah, great question. So for Van Dyke specifically, as you see, it is going through the sales process relatively quickly for some of the projects right now, but it's a big undertaking for KSV. Yeah, like what can you do in the meantime is really wait, keep yourself up to date on the receiver's websites. See what notices they post. They will, provide a one-page summary every number of months, perhaps, but you will see all of the court records being uploaded there as they become available, and you can read through and look at what's happening with the project. Has it been listed for sale? Who is listing it for sale? What's the timeline? But yeah, unfortunately, you just have to wait.
And I guess just to follow up, so let's say that it is a condo property and you have the Tarion protection, I think up until 40,000 or whatever that amount is. I know builders are required to get the additional insurance.
Yeah.
In your experience, and I'm sure, there's not one answer for every scenario, but in your experience, does insurance typically tend to kick in if there are additional deposits that were provided beyond the Tarion protection? And how difficult is it for purchasers to kind of recoup that shortfall amount that Tarion won't provide?
So the limit for condos is $20,000, and then
20.
And then upwards from that, if the money's in the lawyer's trust account, then it's all good. If it has been withdrawn under the excess deposit insurance policy, then like any insurance provider, it may take time to process your claim and get the funds returned. It's difficult to determine how long that might be if there is a claim under the insurance policy. It depends on the wording of the insurance policy. But again, you have those protections in place for a condo compared to the freehold.
Yeah, got it. Thank you.
Thank you so much for asking.
All right. I think we had something from Manjinder, whose hand was up. Manjinder, if you'd like to ask.
Just wanted to ask if because deposits that are given for booking a condominium, they are there with the builder for 2 years, 2.5 years. Do they are the buyers entitled to interest under the Tarion?
Great question. So you do earn interest on deposit funds held in trust for a condo. It's based on the Bank of Canada rate. minus 2%. So between about 2008 and July 2022, it was the Bank of Canada rate was below 2%. So you effectively earned nothing on interest. But as of July 2022, as the interest rates have increased, purchasers have starting earning interest on the money. I believe the Bank of Canada rate is 5%. So therefore, purchasers are earning 3% at the moment.
So do we capture that claim within the Tarion claim form as to the interest also?
Yeah, correct. So if you terminate the purchase agreement, you are generally entitled to the interest as well.
Okay, and other quick question. If the builder is gone into bankruptcy or receivership, and we end up taking the claim from Tarion, are we still entitled to go with the new buyer of the project, whosoever is developing again, or are we out of the race once we take our deposits back?
Well, if you decide well, you generally don't have the option to terminate. If the builder decides to terminate all the purchase agreements, they may offer it to you again as a first offering. Like you are the first offer. Like potentially you could buy it again if necessary. This is where you come along and you hear the stories of cancelling a project and then reselling it for $100,000 more.
So submitting a Tarion claim doesn't stop me from continuing with the project, or although I cannot have an unjust enrichment, but still, I mean, technically I am at par with the other buyers of the project who are similarly placed. Isn't it?
So to clarify on your question, so if you want to terminate, that's not, you want to say, does that preclude me from coming back to the table and buying again?
Yes.
Like it shouldn't put you on the bad boy list if that's what you're asking.
Mm-hmm.
I think that answers your question. Gloria raised her hand.
Oh, sorry about that. I was on mute. All right. As I was
No.
saying, we have time for one more question of the day, and it's going to be Gloria. So Gloria, hit it up. You're going to take us home. Gloria, feel free to unmute yourself and then speak because you're on mute right now. All right.
Oh, maybe not. Okay.
All right. Well, then that she took us home, but
yeah.
Not with much of a question there. All right. Gloria, if you unmute yourself for the next 10 seconds, you can still do it. If not, then I'm gonna wrap this up.
Okay.
So David, thank you sincerely. I will speak to the fact that when you have issues with your files, this goes to bankruptcy, this goes to assignments, this goes to your normal conveyance. David is truly the creme de la creme, and knows his stuff, as you can see. David, we're incredibly grateful for you tackling this. I should mention that when I actually asked for people to tackle, usually people volunteer. In this instance, for this subject, it was only David that volunteered. So incredibly grateful for that. Thank you very much. We will post this in the next couple of minutes. And please accept, again, please everyone accept my apologies about the freehold deposits. Again, that did not make it into the legislation. Everything David had said previously is accurate, and I'm sorry for having confused people in that regard. I wish you all a great day, and we will schedule our next one shortly. Be on the lookout on the forum. Take care, everyone.
Thank you so much.
Thank you.